A challenge to President Trump's sweeping tariffs imposed under emergency powers. And at the same time, the government shutdown continues to cause ripple effects across trade, federal agencies, and the economy. And joining us now is CBS News congressional correspondent Scott MacFarlane, who has been tracking both the legal battle, Scott, and the political fallout. Let's start with the Supreme Court. What's at stake in this case, and how could a ruling against President Trump reshape presidential power over trade?
Hey, Annie, so much going on so quickly, it's easy to lose sight that those were some landmark arguments at the Supreme Court on Wednesday over tariffs, over whether the president has power to unilaterally issue tariffs, to install tariffs, to adjust tariffs, a power that Democrats say the Congress should be holding and shouldn't surrender to the president. The expert court watchers who were there inside the Supreme Court Wednesday had difficulty getting a good read on where the justices are going to come out on this one, which leaves a big variable over tariffs, the U.S. economy, and the powers of the presidency. But this is one of those things you want to keep tabs on, even amid the fire hose of news that is drenching all of us.
Right. And could we see President Trump pivot to other legal tools to keep tariffs in place if the Supreme Court rules against him?
The president has said this is a major issue, if not a primary concern of his amid the many things he's trying to do, that getting rid of the power to tariff, he said, would be destabilizing to the economy and to U.S. power. Would he look to find another way to institute them? It's a good question. I think it's a question a lot of people are asking. The Supreme Court does hold some of the fate of this, though, in their hands.
All right, Scott MacFarlane, CBS News congressional correspondent. We always appreciate your time and your insight.
Most people watching the mainstream media today believe they are witnessing a routine legal skirmish. They see headlines about tariffs, immigration, and courtroom debates, and they look away. But they are missing the most explosive constitutional crisis of our generation. What happened this week inside a federal courtroom wasn't just a legal setback for Donald Trump. It was a total shattering of the executive branch's illusion of absolute control. For the first time in centuries, a forbidden law from 1798 has been dragged out of the shadows, and instead of being the ultimate weapon for the presidency, it has just backfired with catastrophic consequences. You need to understand the gravity of the scene. We aren't talking about a mean tweet or a social media post. We are talking about the cold, hard reality of the federal judiciary. On March 15, 2025, the world of American law shifted. Federal Judge James Boasberg didn't just issue a suggestion, he issued a direct, ironclad court order. He told the Trump administration to halt the deportation flights. He said, "Turn the planes around." This was a test of the most fundamental principle of our democracy. Does the president have to follow the law, or can he simply ignore it? What happened next should terrify every citizen, regardless of their politics. The administration didn't just argue the point, they ignored the judge. 2 planes, carrying 261 Venezuelan migrants, continued their flight path.
Analyst Ellie Holding is a former federal prosecutor. Walk us through the reasoning here from the Supreme Court, which I have to say is truly interesting.
It really is. It's an unusual decision and a major setback for the Trump administration, not just in Chicago, but more broadly. The law that Donald Trump used to deploy the National Guard in the first place says that the president can call out the National Guard if he is unable with regular forces, we're going to come back to that, okay, regular forces to execute the laws of the United States. Now, the Trump administration argued that means if he's unable with regular cops, with FBI, DEA, ICE to enforce the laws, then you can call in the National Guard. What the Supreme Court said is, no. That phrase, regular forces, that means the regular military, Army, Navy, Air Force, Marines, and only those very narrow areas where the military is even allowed to come in and execute the laws in the first place. So basically, the Supreme Court has put the bar very high to deploy the National Guard in the future and has limited it to an almost minuscule slice of all conduct on the streets. It's going to make it very difficult for the president to justify the National Guard in Portland, New York, anywhere else.
Explain why this mattered in Chicago, but didn't play in Los Angeles or in Portland, Oregon, where the Guard was also deployed.
So I think you and I discussed Los Angeles and D.C. were different. D.C. was different. Trump was allowed generally to deploy there because the president is in charge of the D.C. National Guard, okay? Put that to the side. L.A. was different, Los Angeles, because there were protests that at times turned violent happening there. The rationale in Chicago is much more generalized. Just, well, crime rates are high and it's very dangerous. And the Supreme Court has said that's not enough for this specific statute.
Yeah, and again, for it to be allowed in cities like Chicago in these circumstances, it would have to get past posse comitatus, right?
Right. Yes.
Which means what?
You with your Latin phrases, which means that the military traditionally cannot conduct regular law enforcement activities. They can't make traffic stops. They can't do searches. They can really only provide a very basic security function. So it's very, very narrow. So this decision really leaves very limited room for Trump to deploy the National Guard elsewhere. They can try to argue circumstances are different, but if the argument's just going to be, well, it's dangerous, that's not going to cut it.
Where they're not invited is also important, too.
Yes. Well, it's a big difference if the governor requests aid.
Right.
That changes the whole legal calculus. Interesting coalition here, right? We're so used to these 6-3 decisions, 6 conservatives versus 3 liberals. Here you had Chief Justice Roberts, Amy Coney Barrett, and Brett Kavanaugh joining with the liberals, leaving the 3 conservatives complaining about this. This was an emergency docket case, meaning there was not full briefing. There was no oral argument.
They ignored the order, they ignored the bench, and they landed those planes in El Salvador. This wasn't a mistake. It wasn't a logistical error. It was a calculated act of defiance. When Judge Boasberg found out, the atmosphere in that courtroom changed from professional disagreement to a high-stakes constitutional confrontation. At the heart of this storm is the Alien Enemies Act of 1798. This is what we call a forbidden law, a relic from a time when the United States was preparing for a war that never fully materialized. It was designed to give the president sweeping, near-dictatorial powers during wartime to remove citizens of an enemy nation. Trump reached back over 200 years to grab this power, thinking it would be his golden ticket to bypass Congress and the standard legal system. He thought this ancient statute would make him untouchable, but here is where it all shattered. In front of Judge Boasberg, the Department of Justice lawyers found out the hard way that a law from 1798 does not grant you immunity from a court order in 2025. When the DOJ lawyers stood up to explain why they ignored the judge, they didn't have answers. They had dodges, they had excuses. And Boasberg wasn't buying any of it. He looked at the most powerful legal department in the world and told them their answers were woefully insufficient. He didn't just stop at a reprimand, he leveled a threat that has sent shockwaves through the entire administration: criminal contempt. To understand why this is a constitutional breaking point, we have to look at the specific moment the chain of command decided to test the judiciary's patience. It started with a single piece of paper, a court order issued by Judge James Boasberg. The mandate was simple and absolute: halt the deportation flights of Venezuelan migrants under the Alien Enemies Act immediately. In the world of law, when a federal judge says, stop, the engines are supposed to shut down. But inside the Trump administration, a different calculation was being made. They weren't looking at the law, they were looking at their own agenda. They decided to ignore the bench. Despite a direct order telling them to turn the planes around, 2 aircraft carrying over 260 people continued their journey across international borders. They landed in El Salvador as if the court order didn't exist. This wasn't just a logistical failure, it was a brazen signal to the entire judicial branch that the executive branch believed it had found a loophole in the fabric of the Constitution. They believed that by invoking a law from 1798, they had effectively silenced the courts of 2025. When Judge Boasberg found out that his authority had been treated as a mere suggestion, the response was immediate and furious. He didn't just send a letter, he called an emergency hearing. He demanded that the Department of Justice show up and answer for what can only be described as state-sponsored lawlessness. Imagine the scene: high-ranking government lawyers sitting in a federal courtroom, facing a judge who is no longer interested in political rhetoric. He wanted names. He wanted to know who authorized the violation. He wanted to know who decided that a presidential directive carries more weight than a federal court order. This is where the administration's strategy began to crumble. The DOJ lawyers didn't arrive with a solid legal defense. Instead, they arrived with dodges and excuses. They spoke about state secrets and cabinet-level discussions, trying to build a wall of secrecy around the decision-making process. But Boasberg saw right through it. He described their responses as deeply inadequate. He wasn't just annoyed, he was beginning to build a criminal case from the bench. He demanded sworn testimony from those involved in the highest levels of government talks. He was no longer just presiding over a case. He was conducting an investigation into the integrity of the presidency itself. The stakes here are higher than any single policy. If the administration can ignore a court order once and get away with it, the judiciary becomes a ghost. The forbidden law of 1798 was supposed to be Trump's ultimate shield, but in the hands of a determined judge, It is becoming the very instrument that might lead to criminal charges against his own officials. This is the moment where winning a political battle in the streets meets the reality of losing the legal war in the courtrooms. As the emergency hearing progressed, the Trump administration attempted to deploy its final line of defense, the state secrets privilege. The Department of Justice lawyers argued that they couldn't fully explain why they defied the court order because the decision involved sensitive, high-level national security information. They wanted the judge to simply take their word for it. They wanted the court to stay out of the executive's secret business. But this is exactly where the administration's legal theory began to backfire. Judge Boasberg was not looking for excuses. He was looking for the truth, and he was ready to use the full power of the federal judiciary to get it. The moment the DOJ mentioned state secrets as a reason for ignoring a direct halt on deportation flights, the judge's patience reached its limit. He didn't just reject the argument, he dismantled it. He made it clear that state secrets is not a magic wand that makes the Constitution disappear. You cannot use a law from 1798 to bypass the human rights of 261 people and then hide behind a curtain of secrecy when a judge asks why. Boasberg called their bluff, stating that the answers provided were not just insufficient, they were an insult to the court's authority. This is the point where the crisis moved from a policy dispute to a personal liability for government officials. Boasberg took the unprecedented step of demanding a sworn statement from someone at the cabinet level. He wanted a name. He wanted a signature. He wanted someone in the president's inner circle to swear under oath exactly who made the call to keep those planes in the air. This was a direct strike at the heart of the administration's secrecy. By demanding sworn testimony, the judge was removing the anonymity that usually protects high-level bureaucrats. He was putting them in a position where they had to choose between lying under oath, which is a felony, or admitting they intentionally violated a federal court order. The shattering of this state secrets shield represents a massive shift in the power dynamic. For months, the administration believed they could operate in the shadows, using ancient statutes to justify modern-day mass deportations. They thought the courts would be too intimidated or too slow to react. But in this courtroom, the law caught up with the rhetoric. The judge made it clear, if you cite the Alien Enemies Act, you are still subject to the laws of the United States. You are still subject to judicial review. And if you lie to a judge or ignore an injunction, the state secrets privilege won't save you from a criminal contempt charge. The walls are closing in, not just on the policy, but on the individuals who thought they were above the law. While the firestorm was consuming the courtroom in Washington, D.C., a second, perhaps even more dangerous front opened up on the West Coast. If you thought the deportation flight scandal was the only place where the administration was testing the limits of the law, you were wrong. In California, a federal judge named Charles Breyer was forced to step in and draw a constitutional line in the sand that the presidency never expected. This part of the story isn't just about immigration. It's about the very structure of the United States. It's about whether the president can unilaterally seize control of state resources to build what the founders of this country feared most, a national police force. The situation was unprecedented. The Trump administration attempted to federalize over 4,000 California National Guard troops. They didn't ask for permission. They didn't seek the governor's consent. They simply tried to take control of these state soldiers and repurpose them as federal immigration enforcement officers. This was a move of staggering legal audacity. For over 2 centuries, the division between state and federal power has been a sacred boundary, but the administration believed that their interpretation of executive power gave them the right to erase that boundary with a single signature. They saw the National Guard not as state defenders, but as a private army for the executive branch's policy goals. Judge Breyer's reaction was swift and his language was devastating. He didn't just rule against the deployment, he issued a warning that should be ringing in the ears of every American. He stated that if the president has the power to take over state troops without permission, then the concept of federalism is dead. He wrote that such a theory would create a national police force, the exact kind of centralized power that the framers of the Constitution specifically designed our system to prevent. This wasn't just a policy critique, it was a verdict on the administration's entire worldview. Breyer declared that the government's theory of power was, quote, contrary to law. This ruling shattered the administration's momentum. It sent a clear message that the forbidden law strategy was failing not just in one courtroom, but across the entire country. When a judge uses the phrase contrary to law, it's not a debate, it's a shutdown. It means the legal foundation for your actions doesn't exist. Trump's team thought they could use the urgency of the border to bypass the sovereignty of the states, but they ran headfirst into a judiciary that still believes in the separation of powers. By trying to grab too much power too fast, they have ended up with less control than when they started. The attempt to create a national police force didn't just fail, it exposed the administration's hand, and now the courts are watching every single move they make with a level of scrutiny that is making the White House lawyers scramble for their lives. While the lower courts are threatening criminal contempt, the ultimate survival of the administration's economic agenda has moved to the highest level of the American legal system, the Supreme Court. This is where the forbidden law strategy faces its final, most brutal test. The case at the center of this storm isn't just about trade. It's about whether the president has the authority to unilaterally impose sweeping tariffs under the guise of emergency powers. For decades, Congress has slowly surrendered its power over the economy to the executive branch. But this week, the justices began to ask a question that the White House never wanted to hear. Has the president gone too far? Inside the Supreme Court, the atmosphere during the landmark arguments on Wednesday was electric with tension. Expert court watchers noted that this wasn't the usual partisan divide. The administration's lawyers argued that in a modern, fast-moving world, the president must have the flexibility to adjust tariffs at a moment's notice to protect national security. They claimed that the laws granting emergency powers allow the executive to act as a singular economic force. But the justices, including some of the most conservative members of the bench, seemed deeply skeptical of this economic king theory. They pushed back, questioning whether an emergency can be declared simply because the president wants to change a trade deal. This is where the connection to the 1798 forbidden law becomes undeniable. Just as the administration used an ancient wartime statute to justify mass deportations, they are now using emergency economic statutes to bypass the constitutional requirement that only Congress can levy taxes and tariffs. It is a pattern of governance that treats the Constitution as an obstacle rather than a guide. The Supreme Court is now looking at a coalition of opponents that includes not just Democrats but business leaders and constitutional scholars who warn that if the president wins this case, the separation of powers will be permanently broken. The real danger for Trump is the emerging unusual coalition on the bench. We are seeing Chief Justice Roberts, Amy Coney Barrett, and Brett Kavanaugh joining the more liberal justices in expressing concern over executive overreach. If they rule that these tariffs are an abuse of emergency powers, the entire economic foundation of the second term will shatter. Billions of dollars in trade policy could be wiped out in a single afternoon. The administration thought they could use national security as a blank check to do whatever they wanted with the U.S. economy, but they are finding out that even at the Supreme Court, there are limits to how far you can stretch the law before it snaps. The fate of the U.S. economy and the very definition of presidential power now hang in a delicate balance, and for the first time, the White House is realizing they might not have the votes to win. The most terrifying moment for any government official isn't losing a policy debate or seeing a law struck down. It's the moment a federal judge looks them in the eye and mentions the words, criminal contempt. This is the nuclear option of the judicial branch, and in the courtroom of Judge James Boasberg, that option is now officially on the table. We have to move past the political headlines and look at the raw legal reality. The Trump administration is no longer just fighting for a policy. The individuals within the Department of Justice are now fighting to stay out of federal prison. This is where the forbidden law strategy has led them, to a place where personal liberty is at stake. To the average viewer, contempt of court might sound like a minor procedural slap on the wrist. It isn't. When a judge examines whether there is probable cause for criminal contempt, he is initiating a process that can lead to actual incarceration. Boasberg's fury over the defied March 15th order wasn't just performative. By demanding to know exactly who authorized those deportation flights to continue after his halt order, he was building a criminal file. He was looking for the person who signed the document, the person who gave the verbal command, and the person who decided that the presidency was immune to judicial oversight. For the DOJ lawyers sitting in that room, the atmosphere turned from professional to personal in a heartbeat. They realized that following orders is not a valid legal defense for violating a direct federal injunction. This creates a massive psychological shift within the administration. Up until this point, Trump's officials felt protected by the shield of the presidency and the reach of the Alien Enemies Act, but the threat of criminal contempt pierces that shield. It forces every cabinet member and every high-ranking lawyer to perform a new dangerous calculation. Is my loyalty to Donald Trump's agenda worth a criminal record? Is it worth a prison cell? When the stakes are a policy win, people are bold. When the stakes are their own freedom, the cracks begin to show. This is exactly what Boasberg intended. By targeting the individuals rather than just the institution, he is effectively paralyzing the administration's ability to act outside the law. The fallout of this contempt threat is already being felt in the halls of power. We are seeing a sudden hesitation in how orders are being carried out. Career officials and political appointees alike are now demanding everything in writing. They are seeking their own legal counsel, and they are looking for ways to distance themselves from the most aggressive executive actions. The Forbidden Law of 1798 was supposed to simplify the president's power, but by triggering a confrontation with the courts, it has created a maze of personal liability that is trapping the very people Trump needs to execute his vision. The judiciary has reminded the world that while a president may be elected, the law is enforced by those who hold the keys to the courthouse, and right now those keys are being turned against the administration's inner circle. What we are witnessing is not just a series of lost court cases, it is the total disintegration of a legal philosophy. For years, the architects of this second term believed in a theory called the unitary executive, the idea that the president has nearly unlimited power over the federal government, and that once an order is given, it cannot be questioned by judges or slowed down by bureaucrats. They thought the Alien Enemies Act of 1798 was the ultimate expression of this power. They believed they had found a historical cheat code that would allow them to bypass the modern administrative state. But as the rulings from Boasberg and Breyer continue to pile up, that narrative isn't just being challenged, it is being shattered into 1,000 pieces. The administration's strategy relied on the element of surprise and the cloak of secrecy. They thought that if they moved fast enough, if they landed the planes and deployed the troops before a judge could even finish reading the brief, the courts would simply accept the new reality on the ground. They were counting on a judiciary that was too intimidated to intervene. But the opposite has happened. By attempting to use a forbidden law to justify such radical actions, they have forced the courts into a defensive crouch. The judges aren't just ruling on policy anymore. They are fighting for their own survival as a co-equal branch of government. This is the ultimate constitutional stress test, and right now the presidency is the one failing the exam. Inside the White House, the cover-up phase has officially begun, and it is failing spectacularly. When Judge Boasberg demanded cabinet-level accountability, he effectively pierced the veil of secrecy that the administration has been hiding behind. They tried to redaction their way out of trouble. They tried to hide behind executive privilege and national security memos. But the law is a stubborn thing. You cannot use a law from over 200 years ago to seize power and then claim that the details of how you use that power are a state secret. The irony is palpable. The very law they use to exert total control has become the legal fault line that is swallowing their entire agenda. The political fallout of this shattering is that the administration no longer looks like a well-oiled machine. It looks like a regime in crisis. Every time a DOJ lawyer stumbles in open court, every time a judge threatens criminal contempt, the aura of invincibility fades. The public is starting to see the hidden cost of this legal aggression. It's not just about deportation flights or National Guard troops anymore. It's about the fact that the government is spending its energy fighting its own judges rather than solving the problems of the people. They promised a return to law and order, but they have created a constitutional thriller where the administration is the primary suspect. The forbidden law was supposed to be their greatest strength, but it has turned out to be their greatest liability, exposing a level of desperation that most people never thought they would see from this White House. What we are witnessing in these federal courtrooms is more than just a legal battle. It is the final defense of the American constitutional order. The Trump administration reached back into the darkest corners of history to revive a forbidden law from 1798, believing it would give them the power of a king. They thought they could use it to bypass the courts, ignore the states, and silence their critics. But as we have seen from Washington, D.C. to the West Coast, the law has backfired. Instead of a shield, it has become a mirror reflecting the administration's own desperation and its disregard for the boundaries of power. When the history books are written about this era, this week will be remembered as the moment the executive branch's illusion of absolute control finally shattered. The true bombshell isn't just that the administration lost a few cases, it's that federal judges have started to treat government officials as potential criminals for violating court orders. The threat of criminal contempt has changed the game. It has turned a political crusade into a personal liability. If the president can ignore a judge on Monday, then the law means nothing on Tuesday. That is the fault line we are standing on. Judge Boasberg and Judge Breyer aren't just protecting migrants or National Guard troops, they are protecting the very idea that no one is above the law. They are proving that the checks and balances designed over 2 centuries ago still have the power to stop a power grab in its tracks. But the question remains, what happens next? If the administration continues to defy these orders, we are headed for a crisis that could tear the federal government apart. If they comply, their most aggressive campaign promises will be dead on arrival. Either way, the forbidden law strategy has failed. It has exposed the limits of the presidency and empowered the judiciary in a way we haven't seen in generations. The administration tried to test the system, and the system is fighting back with everything it has. I want to hear from you in the comments. Which of these courtroom bombshells concerns you the most? Is it the threat of criminal contempt, or the attempt to create a national police force? Let's start the conversation below. Don't let the media tell you what to think. Look at the facts, look at the law, and decide for yourself. Thank you for watching, and stay tuned, because this constitutional thriller is far from over.